Welcome to the Essential Tax Podcast with your host, Mishkin Santa. In each episode, we'll take the complex world of tax, all the jargon, acronyms, and stuff that make your eyes glaze over, and explain it in an impactful way to understand the complex and unknown areas. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, thewolfgroup.com. Now, here's the host of Essential Tax Podcast, Mishkin Santa.
Hi, everybody. Welcome to the podcast. So most of the podcasts I've done have revolved around income tax or international cross-border tax or informational forms for cross-border reporting. Today's podcast, I think, is going to be really awesome because we're going to talk about a topic that we haven't broached yet on the podcast, which is estate planning, estate tax. And I've brought in who I believe is the best in the business. So John Dedon, welcome to the podcast. Great to have you here.
Thank you, Mishkin. Great to be here.
All right. So John, just so that we can set the table, could you just tell our listeners a little bit about yourself, just kind of your background, licenses, who you work for, all that stuff?
Well, I'm of counsel with a firm here in Fairfax, Virginia. Been doing this for 30 plus years. Had the privilege and the pleasure to work with the Wolf Group for many of those years.
Yep.
So I'm dating not only myself, but also some of your partners. But my practice is exclusively estate planning, and estate planning can be pretty broad. It can include fundamental planning, advanced tax planning, working with business owners. You become somewhat of a family counselor as well, because a lot of the planning is not related to tax. It's related to how to protect the children, concerns about divorce of the children. So you get into a host of issues that encompass all of that within the realm of estate planning. And charitable planning comes into that as well. Foundations, donor advised funds, etc.
Great. And I want to touch on all those topics. But to set the table for the listeners, so just so everyone understands, there is a federal estate tax, despite what I believe the Senate Majority Leader John Thune for years has been trying to do, the repeal of the Death Tax Act. And I don't think it's gotten any traction. So we still have the estate tax, federally speaking. And then for those that are in the Maryland, Virginia, DC area, specifically, just also remember that there is state estate tax that could also apply. So Maryland, for example, has a state estate tax. So does DC. I don't believe Virginia does. So there's a couple layers that you have to be careful with when it comes to the quote unquote estate tax. As part of the One Big Beautiful Bill Act, the estate tax exemption, the unified credit, was increased to $15 million. And I think it's indexed for inflation maybe starting next year, going forward. So John, tell us about where we're at right now with the estate tax, things that you're thinking about, maneuvers that you're looking at, how you're approaching that with your clients when you're starting to do the estate planning.
Well, your summary was terrific because, as you said, few states have an estate tax. Maryland happens to have a $10 million exemption, and as you said, the federal is 30. But most states don't have any estate tax. Virginia is one of them that does not. So you then say, okay, well, we tried to eliminate the estate tax through the years. And in fact, they were on the verge of doing that when Katrina hit. And
really?
It was not a good idea to be talking about protecting the wealthy when people were struggling. That was really the last time when there was a serious ability to eliminate the estate tax. So where we are now, it is at 30 million. It's 15 million apiece. I do want to point out that Vice President Harris, for example, her platform was $7 million. And so the law can change, but what's different from prior years is it's not a sunset law anymore. It used to be at the end of every December, there was a threat that the exemption amount was going to be reduced because the law automatically sunset. Now it would take a different president and a change of Congress to reduce it. But it is possible if we have a sea change in the political climate in 3 years. One other thing that I want to mention that is perhaps as important as the exemption amount, there's this concept that's become prevalent and well accepted and pretty much in stone, and that's called portability. Portability simply means if you are a husband and a wife, as a team, you get the benefit of each spouse's exemption. And why that is so important is because in the old days, if you had 5 million or 10 million or 2 million, you had to divide the assets up to get the benefit of each spouse's exemption. It made the planning much more complicated. So even if they changed the 30 million, even if it did go down to say 7, you get $7 million if you are married. You don't have to try to put 3.5 in each spouse's name. So this concept of portability has really helped as a sound public policy in doing tax planning, just like a marital deduction is good public policy. You can leave assets to a surviving spouse without any tax at that time. Portability is similar to that.
And John, just for the compliance nerds listening to the podcast here, I believe there are some things you have to do to get the portability election. You have to make a timely election on an estate tax return, or are there any danger zones with the portability election where you may miss out on it? I'll put it that way.
Yeah, the danger zones this is a relatively new concept. I mean, at this point, it's not all that new. It's a few years old, but there were several deceased people who would not claim the exemption. As you point out, you need to file an estate tax return. So here's the perspective there. If you just work with today's amounts, if you have less than $15 million, you don't technically need to file an estate tax return. That's not 100% true in all situations, but just generally, there are times when people would die, there's no need to file an estate tax return because the deceased spouse was under the exemption amount. But if you want to claim the portability election, you do need to file an estate tax return, if only for the purposes of claiming that exemption. And through the years, as we said, this is a fairly recent concept, a lot of these deadlines were missed, and the government, to their credit, was pretty liberal in extending deadlines. But at this point in time, there is a deadline, and you must be aware of it. And when I meet with a widow, I'm always cognizant of what is the net worth, and should we be filing that portability exemption as a protective measure?
Yeah, and I think that's a best practice that a lot of people overlook or don't think about. And I think that's one big takeaway to the audience today is that, that's something that you definitely want to plan for and make sure that your accountant or whoever's dealing with that kind of takes that into their, perspective when they're preparing the documents. Okay, so I get a lot of people that come to me and they say, Mish, I want to do a will, I want to do a revocable trust, I want to do, medical power of attorney, health power, they start rattling off, 10 different things. And I always have to remind them, like, hey, Wolf Group, we're an accounting firm, we're not a law firm. If you want to do all that, you got to go see John, or I got to pass you off to the estate planning attorneys. I could tell you what I think you should do, but I mean, they're just going to have to review it from scratch and kind of, give you real legal advice there. So, what's your general take on, planning tools for death, things that people should be aware of? Can you give our audience maybe, some hot tips to think about or take away?
Well, we started with kind of estate planning 301, meaning if you have in the neighborhood of $30 million, or you're about to sell a company and you think you will, we're in estate planning 301. You don't want to pay a 40% estate tax on your net worth because it's significant and we need to take steps to combat it. But the reality is most people do not have $30 million. And so where do you start? Mish, it's NFL draft day today. So
Yeah.
where they need to start is with blocking and tackling.
Okay.
And that takes us to what you were just alluding to. And that is everybody. I mean, everybody, whether you have $100,000 or $100 million, everybody starts with a will. We know about wills, powers of attorney and medical directives. We can talk about those. And I believe a revocable living trust. Those are the 4 documents that virtually everybody needs for purposes of their blocking and tackling.
Gotcha. All right. Tell us about them.
Well, let's start with your living, but you're incapacitated. Incapacitated means you could be 100 years old and you're starting to lose it, or it could mean you're in an accident. Well, you don't want a judge to appoint a guardian for you. And that can be the case, even if you're married or even if you have adult children. So how do we address that incapacity issue? You address it with 2 of the 4 tools I mentioned, a power of attorney and a medical directive. So the power of attorney names an agent for financial purposes. The medical directive does the same for health. And, the likely candidates are typically spouses, children. Sometimes people don't have those candidates and you look to friends or extended family. But those documents are absolutely critical for anyone who is living but incapacitated. And just while I think about it, a lot of clients come in and we're focused on their planning. And then they say, hey, by the way, my 18-year-old is going off to college. Well, it's going to be a rude awakening when they may be writing a check for tuition, but they don't have access to the kids' grades, or the child has a problem. They can't get medical records, even if they fly out to the campus. So again, my point is any adult should have a power of attorney and a medical directive.
And on those documents, typically those are witnessed or notarized. Like you have to have like several witnesses, 2 to 3 witnesses.
It's state law specific, but the practice in this office is just to make sure they're valid in all 50 states. We have a notary and 2 witnesses for every power of attorney and medical directive we do. As I said, in Virginia, it says happy. When you do the one in Maryland, it says glad. They're all accomplishing similar things. They are all different, but they're all essentially the same for the solution to the problem. And that is, I want to name the person to handle my financial and health matters, not put it in somebody else's hands.
Right. And I don't think the people witnessing can be related to you, right? They have to be non-blood related.
Again, it can be state specific, but that's why I sometimes there's always a rare instance, but I tell people you should go to your attorney's office. We have the notary, we have the unrelated people. I know where to initial. So there is a formality to this. In this day and age, oftentimes clients will say, hey, DocuSign. It's like, no. I know you can sell a $3 million home with DocuSign, but I need you here in person.
Gotcha. Okay. So there you go, folks. Don't go down to your local bank and see if they can do it with a notary down there or some random FedEx store or something like that. You got to go to your attorney. They got to draft the paperwork. You got to sign it and initial it with them at their office. They'll make sure all the bells and whistles are tied out there. Okay.
Correct.
So we've got the POA, we've got the medical directive. What's next?
Well, so then what we have is a will. People know, well, I need to have my will in place. Well, the issue with the will is wills do not avoid probate. Revocable trusts avoid probate. So I guess this is the appropriate time to say, what's probate? Who cares? Well, I care a lot. Probate is low-hanging fruit, the idea that anyone can avoid it.
Okay.
And so first let me talk about the process. In general, here's what the process means. Whether you're in Virginia or Texas or California, it's all more or less the same. And what it means is the local county says, we have a responsibility to see that upon death, the assets go where they're supposed to, and the creditors get paid. And if we're going to take that responsibility on, we need a lot of information so we know it's being done right. And that information is not a tax. It's simply a cost for the county to have the people to look at the forms. And then it's the cost of the deceased estate hiring the attorney or the accountant or whoever else to fill out all the paperwork. And after a year or two, this process is complete and the assets go where you want them to go. But that process not only is very expensive, but it's a huge hassle. And in Virginia, it applies if you have more than $75,000 of assets. And again, that's state specific, but that's pretty much, it's not a lot of money to trigger probate. And people are under the misconception, oh, I have a will. What are you talking about? I've done what I need to. Well, no, as I said, a will does not avoid probate. So Mish, let me take a step back and say, okay, I want to avoid probate. I get the sense of that. How do I do it? And how do it leads us to how do assets pass upon death?
Okay.
And this also is very important because it's not unusual to have clients who say, I have my will. I've done everything I need to. And then you dig a little deeper and you say, well, who's the beneficiary on your life insurance? Well, it's your former spouse. Well, that's probably not what you want. Right. So here's the point. Assets pass upon death by beneficiary, regardless of what a will or a trust say, or they pass if they're jointly titled. They go to the joint owner. So when you wrap in this discussion of avoiding probate, it leads you to, you have to coordinate universally. How are my assets going to pass? And what as a beneficiary? What as a joint owner? What may be titled in the name of my trust? So not only am I pointing out we want to avoid probate by having a revocable trust, not just a will, but you need to coordinate the titling and the beneficiary so that they all fit together. So a will is an important document, but it's typically the revocable trust that does the heavy lifting to avoid probate. And then you work with clients to ensure their assets are properly titled and the beneficiary designations are appropriate, consistent with their estate planning documents.
And for the revocable living trust, I think a lot of people talk about, well, I'll just make sure I title everything, put everything over. There's some special things to be careful with, right? With real property, as far as putting the title to your house, for example, in a revocable living trust. I think you have to be real careful with how you do that. The other thing I've noticed is that some people will come to me and say, yeah, I've got this, this revocable trust, and they haven't titled it. Nothing's been titled or put into it. So they just got the trust with nothing actually inside of it. It's the final step that was missed there. So any thoughts on the titling of assets into the trust that you want to share with the audience?
Yeah, I got a lot of thoughts on that because a lot of people may have wills but no trusts, and a lot of people have trusts, but as you say, they haven't executed because nothing's in the trust.
Right.
So it's not as if the trust is self-funding. Oftentimes people say, where in my trust does it say that my brokerage account? Well, the brokerage account is not in the trust unless the brokerage account has a transfer on death designation, which is a beneficiary that names it as the beneficiary, or the title of the brokerage account actually has the name of the trust on it. And so you have to get to the goal line. It's one thing to create the trust, but you don't cross the goal line and get the full benefit unless you fund it. And to kind of get to the punchline, just as the law has been helpful these days with a $30 million exemption that removes estate tax from a lot of folks, The law is also helpful in that you can put a beneficiary designation on virtually any asset. It's the greatest thing since sliced bread, beneficiary designations. So here's what I mean. Traditionally, an IRA, a 401k, life insurance, they all had beneficiary designations. Well, now you can put a beneficiary designation. It's called the transfer on death or payable on death. You can put a transfer on death designation on a checking account, a savings account, a brokerage account. You can even record a deed and do a TOD on real estate in most states. So
Wow.
The point is, we need to solve the problem. We need to avoid probate, but we also want to take the path of least resistance. We don't get extra credit to do change a title or do a beneficiary. We just need to make sure we've solved the problem. So a lot of the ways that you can avoid probate these days is for assets that already have beneficiaries. That's great, but use beneficiary designations for other assets. And that way it's consistent with most people wanting to maintain an account in a joint name, for example. If all of that fails, we still have tried and true, which is I got my trust, just move the assets into the trust, period, you're done.
Gotcha. So let me ask you this, because I'm going to do an analogy for you now. So you said earlier today's the NFL draft. I'm a big New York Giants fan. We've got the number 5 and the number 10 pick. I want defense because that's what we need. That's like, so for number 5, I'm like, we need defense. Like we got to have it. If someone comes to you, let's say a young couple, maybe like my age, me and my wife were to come to you, you got these 4 things: the will, the trust, the POA, the medical directive. Almost like the draft. Like, which one do we tackle first? Which one am I doing at the number 5 pick? Which one am I doing at the number 10 pick? Which one am I doing at the second round, third round? Like, in what order should I look at trying to knock all of these out?
There's really not an order. This is it. In other words, when you show up, I only want to do these 4 documents for you. This is the core.
Okay.
Because depending on what life brings you, if you don't have one of those, I don't want to be responsible for why, I tell, or your child's asking me, why doesn't mom have a power of attorney? I can't handle her assets and talk to the bank.
Right.
Or why did you just do a will? Do you understand I'm spending now all this money and every day of my life filling out forms trying to get through probate? So I'm at the point where I do tell people, I say, listen, if you want my help, here's what it is. It's these 4 documents. Or if you're married, obviously there's 7. Sometimes you can do a joint trust. So my point is, it's a package. I don't want to leave any of it out.
Okay. Very good.
By the way, just as an aside, you may need Bill Parcells. I don't know if you can get him at this point, but you may need more for that franchise than just a couple draft picks. But we can talk about that different.
Absolutely. Funny enough, John, I actually have from the 80s the old Bill Parcells when he was the head coach. I've got the sweater. It was my dad got it back in the 80s. We lived in New York for a long time, and he gave it to me. So I've got the old sweater that I wear sometimes. Okay, let's get into a little bit more of advanced stuff here, because I know one of the areas that we've worked on together is foundations, and you have published several really awesome papers that I refer to regularly when people ask about foundations, because it's not something I do very often, and I always have to say, well, wait a minute, John's the expert. Let me go look at John's paper on it. Talk to us about foundations. Where are we at with foundations now? I mean, TCJA kind of changed the ball game a little bit. Now we've got the One Big Beautiful Bill Act. How's this all affecting foundations? When are foundations useful and effective? Should people be thinking about that for their charitable planning? You're now here in 2026, going into 2027. Give us the scoop.
Well, there are some income tax issues and how you get deductions and so forth, and I always throw that back to folks like you who are much more up to speed on the income tax side of things.
Right.
But when you look at foundations, here's the big picture, and there's also confusion here. I mean, I have a very wealthy client down in Florida, And his accountant sent an email to this client and me and said, hey, you got these 6 charities. The return's asking me, what are they? Are they private foundations, private operating foundations, supporting organizations? What are they? And the client says, I did not see where you mentioned C3. Aren't they C3s? And so I said, Bill, here's the deal. All of these are C3s. And so again, to start at the high level and work our way down, charities can be public charities or private foundations. And now there's a host of other options. For example, a church is a public charity, but all of these are charities. Ideally, you want to be a public charity because there are certain advantages to being a public charity. But if you are an individual, just to get to the heart of the matter for most of your audience, if you are an individual, you're not going to, and you're a wealthy person creating your own charity, you're not going to be a public charity. You're going to be a private foundation. If you're a private foundation, you still get a lot of benefits. But now you're into the world of compliance as far as having to file a tax return every year. And you have to get your foundation created with the 1023, which is the application that goes to the IRS. Now, this can be routine, literally with the age and how long I've been doing this, I've done 100 of these foundations. So they're routine to get created. But here's the point. When somebody says I need a foundation, I always probe a little because I would much rather have them start with a donor advised fund if that's possible. Now, what's a donor advised fund? You can set a donor advised fund up with virtually any financial institution. And by that, I mean a Schwab, a Vanguard, a bank. They have donor advised funds. There's really no compliance to that. And the advantage is, as I said, no compliance. You make the contribution, and then you're able to sprinkle assets out over time. For people who don't want to give, though, to public charities, and think of public charities as your school and your hospital and your church, but they want to give to individuals. Now, they want to provide specific scholarships, or they want to provide grants to a charitable class of individuals. You can't do that through a donor advised fund. You need to do that with a private foundation.
Okay.
Or you need to give through the church, for example, when your church gives to these individuals. But I just wanted to set the table that there's a lot of different types of charities. And for individuals, I try to steer them to a donor advised fund if they're giving other than to the United Way or their church or their school. And only if they have special needs. And the special needs are typically individual scholarships or grants. Do we then look to the private foundation?
Okay. And so if someone came to you today and said, look, I that's what I want to do. I have some special needs that I want to do giving, but I'm only going to give 10,000 annually or whatever it is that enough to kind of get it done? Is there like a special dollar amount threshold that that you're looking for to set up the private foundation? Or
yeah, that's a tough question in the sense that you could have a situation where somebody sold a company or sold a stock and has a big gain and they want to offset the gain. So maybe they have $100,000 or $500,000 they're going to they'd like to contribute. Well, if they contribute to a private foundation, the law says essentially you have to distribute 5% of the assets each year. So, back to your question, if they want to give $10,000, $20,000 a year to specific individuals for scholarships, but they want a big income tax deduction because of an event in a specific year, they could give to a private foundation. The money is invested within the foundation, and the only obligation is to pay out 5% a year. So that's a scenario where you want a bigger deduction, even though the payout each year is not significant, and you can build up the endowment if the assets are appreciating at greater than 5%. On the other hand, if you took that same scenario and they didn't want to give to individuals, but they wanted a big deduction, it would take me back to consider a donor advised fund.
Okay. So it sounds like you got a couple different paths you'd work under. Last question on the private foundations. If I create my own private foundation, what tax compliance do I have? Is there an annual return that I need to be filing for that, or?
That's the 990 PF. And, I don't do those. I'm sure some attorneys do, but, it brings up a point. And again, I'm harping on the same thing. Donor advised fund, there's no tax compliance. A private foundation, there is. And when people go down that private foundation path, I tell them, I'm going to get this created for you. I'm confident of that, or we wouldn't be filing it. But ongoing, you need a CPA who knows their way around foundations, because the compliance to file that return is critical. I've done my job. And of course, I'm available if you want to call me up and ask me questions about specific things. But I'm not the boots on the ground guy who every year is going to file that 990 PF. And, that should not be the CPA who's in the basement and does tax returns because they know their way around 1040s. You need to find somebody who knows their way around charities.
Yeah, I've got a couple of good we don't do that at the Wolf Group. We don't do 990 PFs, but I know a couple of different firms that they have a specialist that does that and very good at it. Okay, well, we're here at the end. John, if someone wanted to contact you or get your advice or have you work with them on their estate plan, what's the process for that? Should they just should they look you up on Google? Obviously, we'll add all your stuff onto the show notes for, so people can access your website and, your profile and all that stuff. But what's the best, how do they contact you? What's the process normally look like for talking to you? Are you booked 6 months out? How's that going?
No, I'm not 6 months out. I'm pretty much 24/7. I mean, Len Wolf would not have kept me as one of his friends and referral sources if I wasn't more responsive than 6 months out. I would have been long gone. But they can simply Google me.
Okay.
They can find me on Google. I'm at Cameron Ingersoll Roche. And obviously lawyers are state specific. I'm in Virginia, DC, Maryland, as you had mentioned earlier.
Okay, awesome. Well, yeah, just for those listening on the podcast, we're going to link all of the profiles, his website, all the good stuff to the show notes. So certainly you can find John there. If you want a direct contact, though, you're always welcome to come to me, and I'm happy to link you up with John one-to-one. We barely scratched the surface of what John does and is capable of, but I don't want to go too deep and wide into this topic on today's podcast. So maybe John, you'll do us a solid and come back, next year or something and give us another update. But appreciate you coming on the podcast today.
Thank you. I appreciate you inviting me.
All right. Thank you.
You've been tuning in to the Essential Tax Podcast with your host, Mishkin Santa. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcast, Spotify, and on our website, thewolfgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.